Hello everyone, welcome back to Michelle's Medicinal Marijuana. Groundhog Day 2009 has proven victorious for the Vancouver Island Compassion Society. In 2004, Matt Beren was charged with cultivation, and now he has been given an absolute discharge. That's right, an absolute discharge for that cultivation charge. I want to tell you this is such a relief. Matt will now be able to continue his research and producing safe, clean cannabis for patients of that club. I was privileged enough to be in the courtroom, and I also took footage of the press conference that happened afterwards. I'd like to say that the legal team did a fantastic job, and I also want to thank all the people who donated and who also contributed and gave their support to this case. This has now set a precedent in BC, which is badly needed. Thank you all for watching, and please watch the footage. I will do a future show soon, but in the meantime, I have a lot of hard work to do, and you can see I'm trimming. Love you all, get involved, and thank you for watching.
Cannabis Research and Distribution's non-profit center, and we currently distribute cannabis to about 850 people with doctor's recommendations, mostly in the greater Victoria area. We're currently producing more medical cannabis research than any organization in Canada. This court case has been almost 5 years in coming in terms of getting to this decision. The original raid on our research center took place in May of 2004. Throughout that process, we spent countless days and untold energy and resources defending the rights of medical cannabis users to access a safe source of cannabis from an environment that's conducive to healing. And today, despite the findings of guilt for Mr. Beren, we feel that our case and our cause has been justified, certainly exemplified by the absolute discharge, or the absolute discharge that the judge subsequently issued. As was stated earlier, this case, as part of this case, the judge in question struck down Section 41B1 and Section 54(1) of the Federal Medical Marijuana Program as being invalid and arbitrary and constitutionally invalid. The judge has granted Health Canada 1 year to remedy to this situation. For lay people, that means that the limits on the number of people who can produce cannabis and the number of people who can produce cannabis on one site have been struck down as arbitrary, as not being supportive of the interests of medical users or greater Canadian society. And once again, this is a finding of this federal program that's found it unconstitutional for the 5th time in so many years. We absolutely have to find a better way to make changes to this program that to continue to prosecute medical cannabis users and those who are working so hard to help them. And it would behoove Health Canada to start a dialogue with medical cannabis users throughout Canada to get a program that is both constitutional as well as effective. The judge in her findings found Mr. Beren guilty of the counts, but then granted him an absolute discharge, citing, and I quote, that in her experience, she had never seen a case that so merited an absolute discharge. Not only did she find Mr. Beren to be a gentleman of good character, but she found that the cannabis that was being grown for the Compassion Society for the use of medical users, as well as for the production of medical cannabis research, which she felt was much needed in Canada, certainly defended the reasoning to give Mr. Beren an absolute discharge. Now to talk about the outcomes of this and the relative impacts of this finding, I'll pass it over to Mr. Kirk Tousaw, the chief litigator in the defense, and also Mr. John Conroy, who was also involved in the preliminary portions of this court case. Thank you very much.
Well, so I'm not sure how much I can add to Mr. Lucas's legal analysis. I'll indicate that my view of the decision is that while the judge found that there was a role for physicians to play in the program, she did not make any findings with respect to whether or not the program was actually meeting the needs of chronically and critically ill Canadians. In other words, She did not want to step into and pass what she called the delicate boundary between the role of the courts and the role of Parliament on the access end. And when I say the access end, I mean access to the legal protections afforded by the exemption program put into place by Health Canada. In order to qualify for an exemption to use marijuana for medicinal purposes, you need to have an application signed by your general practitioner if you fall into one of a narrow range of symptoms and conditions. All other persons are required to have a physician sign their application after consulting with a specialist in the particular condition. The witnesses that we put forward testified to a tremendous amount of difficulty complying with what we say were the unconstitutionally strict entrance requirements. And we principally relied on the Morgentaler case and the Therapeutic Abortion Committee regime that was struck down ultimately by the Supreme Court of Canada as basically creating a barrier to access, not facilitating access. Now, Madam Justice Koenigsberg was not prepared to go down that road. She essentially upheld the determination of the Hitzig Court of Appeal from 2003 that using physicians as gatekeepers into legality for this program was an appropriate exercise of Parliament's discretion. She did, however, strike down portions of what we call the supply end of the program. What happens is that if you're a designated grower, if you're growing for a authorized person, someone with a license, you are restricted by Health Canada to growing for only that person, and it is impermissible for you to hold a license to grow for anyone else, including yourself. So if you happen to be a patient who produces marijuana for yourself, you can't produce it for someone else, your wife, your cousin, your friend, someone that buys it from you. That's impermissible under the 1-to-1 ratio restriction. That has been struck down. Also, prior to today, it was impermissible for more than 3 licenses to be held at any one physical site. So in other words, I could rent a warehouse as a designated producer, have a nice, safe, secure production facility, but I couldn't have more than 3 licenses. That disallowed things like growers' collectives where a bunch of patients get together, pool their resources, and decide to have a community garden. That was impermissible prior to today. Madam Justice Koenigsberg found that to be unconstitutional. She struck that restriction down as well. She stayed her declaration of invalidity for a period of a year, which is relatively common in constitutional cases, basically in order to allow the government to step in and fill the void that was created with some reasonable and constitutional regulations. Now, unfortunately, in the wake of the Hitzig decision in 2003, which struck down these very provisions, the government's response was to reinstate them and to start selling a single strain of pre-ground, pre-dried, gamma-irradiated cannabis to sick people for $5 a gram. That has been found not to be a sufficient constitutional answer to the restrictions. She said the restrictions were arbitrary. In other words, the government's justifications for those restrictions didn't hold water. And so we hope, and it's our earnest desire, and we will work with Health Canada at any time to craft a set of regulations that addresses this decision, the findings of the decision, and the needs of Canada's sick and suffering citizens. Unfortunately, Health Canada has been unwilling to engage the most important stakeholders, the patients and their caregivers, in legitimate dialogue about what we can do to fix this program once and for all so that we can stop putting sick people through the ringer of the judicial process, so that we can stop arresting caregivers for sick people, and so that we can stop wasting the taxpayers' money trying to prosecute people that are growing for compassionate purposes. The only way to do that is for Health Canada and the Parliament of Canada to sit down with people, legitimate stakeholders, and find a way to have a program in this country that works for everybody. Because 8 years of litigation is enough. It's our position that we need to have a program that works, and not one that works just because we have to keep going to court to get orders finding it unconstitutional. I'll look to Mr. Conroy to see if he has anything to add to that position.
The only thing I would add is that this is the first High Court decision in British Columbia. All of the prior decisions were Ontario and other provinces. So we now have a British Columbia Supreme Court decision which is binding on our provincial courts that finds these sections of the medical marijuana access regulations to be unconstitutional. Didn't go quite as far as we hoped in terms of the doctor access issue, but struck down the two regulations that Kirk just mentioned. There's the 1-year suspension, so we'll wait and see what the government does over the next year. They're unlikely to appeal this decision. It's questionable that they have any appeal because Mr. Beren was found guilty, so governments don't usually appeal those sorts of findings. And we'll have to consider whether there's any interest in appealing some of the other issues, but given the absolute discharges on 2 counts, or the 2 major counts, and given the findings striking down the regulations, I think it's a very good decision in terms of medical marijuana in the province of British Columbia, and hopefully will continue to have an impact throughout Canada.
Before passing it over to Mr. Beren, I'd like to say that on top of her findings, the judge found that there's between 400,000 and 1 million Canadians that currently claim to be using cannabis for medical purposes, and yet currently through the Health Canada program, only 2,600 people are protected from arrest and prosecution, and obviously this is an untenable situation. The judge went on to urge the federal government to license and regulate clubs and to work towards a licensed and regulated system for distribution that would create a safe source of cannabis within an environment that's conducive to healing. I'd like to thank the witnesses and who took the time and energy to come and speak in this case, particularly the medical cannabis patients themselves. I'd like to thank our supporters and our sponsors in this expensive and lengthy trial. 90% of Canadians support the medical use of cannabis, and those 90% of Canadians expect and deserve so much better from Health Canada than this continued failed and expensive program. Canadians deserve a program and medical cannabis policies that are based on science, reason, and compassion, not fear, prejudice, and misinformation. And so we expect Health Canada to respond accordingly. Thank you very much. I'll pass it over to Mr. Beren.
I don't have too much to say. It's been a really long journey. It's over 5 years. I'd like to thank Ronald Ranger. Back when this started, we came across. It was a glaucoma patient. He just wanted to smoke cannabis to see. He just wanted to see. And he was mugged and raped on the streets trying to find medical marijuana. We found him at the Compassion Club. We gave him free cannabis for the rest of his life. He's not with us anymore, but I just hope that this kind of activity will cease. People that want medical marijuana for their medical needs will get medical marijuana for their medical needs without the dangers of the street or the dangers of someone growing cannabis and adding stuff to it that doesn't need to be there, or just it's fantastic. It's an awesome day. It's been a long journey, and I'm happy.
Matt, you must have had a bit of a start when the judge.
Woo! All right, Matt.
You must have had a bit of a start when the judge said guilty.
Of course, a roller coaster ride. She said guilty. Outside, they were talking if I was even eligible for a conditional discharge, and talking 14 years to life. 14 years to life for what? Helping people like Ronald Ranger?
Yeah. Did you ever think of that when you started doing this? That you'd be running these consequences?
Yeah, for sure. But I'm walking my truth. I'm helping people. At the time, my decision was if you wanted to put me in jail for helping out a guy like Ronald Ranger, then I'll go to jail, because I'm going to help out guys like Ronald Ranger. They can't help themselves.
You're a hero, Matt. You're a hero to all Canadians.
Here.
Thanks, Matt.
Thank you very much.
I stand between sister to a dream.